All right, let's get right into it. Today, we're going to break down one of the most important laws in fair lending, the Equal Credit Opportunity Act, or as you'll hear it called, ECO. We're going to cover what it is, why it's so critical, and what it actually means for you on a day-to-day basis.
I want you to just imagine hearing those words for a second. For millions of women, this wasn't some bad dream. It was just how things were. This one sentence perfectly captures the kind of financial world that existed not that long ago.
And that right there, that is why we're talking about ECOA. That statement wasn't just a stray opinion, it was standard practice. The law was created to dismantle this kind of systemic, and back then, completely legal, discrimination in the credit industry.
Okay, so here's our game plan. First, we'll get into the big why behind the law. Then, we'll dive into the core rules, what you absolutely need to know. After that, we'll get super practical with a guide for MLOs. Talk about how to handle the final decision, and wrap up with compliance and what happens when things go wrong.
So, let's start with Section 1, the big why. What's the whole point of this law? Well, it all boils down to promoting fair and equal access to credit for everybody. The mission is crystal clear in Regulation B, which is basically the rule book that puts ECOA into action. The goal is simple but incredibly powerful. A creditor cannot discriminate against an applicant on a prohibited basis. That's it. Your job is to look at creditworthiness and nothing else. The law is there to make sure everyone is judged on their financial merits, period.
Okay, so now that we know the why, let's get into the how. Section 2 is all about the core rules, and everything revolves around this one key legal term, prohibited basis.
So, what in the world is a prohibited basis? Well, think of it as a list of characteristics that are completely off-limits when you're making a credit decision. These are the protected classes. If you use any of these factors to negatively impact a credit application, you're breaking the law. And here is that all-important list. You've got the ones you'd probably expect, right? Race, religion, national origin, sex, marital status, and age. But look at the last two because they're absolutely critical. You also cannot discriminate against someone because they receive public assistance income or because they've exercised their rights under the Consumer Credit Protection Act. Quick tip. For anyone studying for the NMLS exam, you have to know this list cold. Make a mnemonic, a song, whatever it takes, just lock it in. Okay, theory's great, but let's make this real. Section 3 is all about putting this into action. How do these rules actually translate into what you, as a loan officer, can and can't say or do?
You know, this is the question that trips up so many people. The general rule is pretty simple. You can ask for whatever information you need to determine if someone is creditworthy, unless it wades into one of those prohibited areas. Let's look at a couple of big examples. Here's a huge one: income. You absolutely cannot just see that someone gets public assistance or alimony or child support and automatically discount it or refuse to consider it. No way. Instead, you have to do your job. You evaluate it the same way you would salary from a W-2 job. Is it consistent? Is it likely to keep coming in? The key is that protected income gets the exact same objective review as any other kind of income. Okay, here's another common trap: asking about a spouse or marital status. You can't just ask about a spouse if they have nothing to do with the application. But, and this is important, there are exceptions. You can ask if the spouse is a co-applicant, or if their income is being used to qualify for the loan. You can also ask if the property is in a community property state, or if the applicant relies on alimony from that spouse to repay the loan. It really all comes down to what's need to know versus nice to know.
Now, check this out, because this part of the law goes beyond just the formal application. It's the rule against discouragement. What it means is you can't say something, even off the cuff, that would make a reasonable person from a protected class feel like, maybe I shouldn't even bother applying here. This applies to your ads, to phone calls, any interaction. It's about making sure the door feels open before they even start filling out the paperwork.
So, you've taken the application, you've done the analysis, and now you've made a decision. Section 4 is all about how you have to communicate that decision, especially when the answer isn't yes.
First things first, we have to understand the term adverse action. And listen, it's not just a flat-out denial. The regulation defines it as any refusal to grant credit on the terms the applicant asked for, even if you come back with a counteroffer. It also includes terminating an existing account. Anytime you take an adverse action, a very specific set of rules gets triggered.
And here are those rules. Once an application is complete, a 30-day clock starts ticking. You have to let them know your decision within that window. If it's an adverse action, the notification has to be in writing, it has to spell out the specific reasons for the decision, and it has to include the name and address of the federal agency that enforces ECOA for your company.
So what do they mean by specific reasons? You can't just write bad credit and call it a day. The law actually provides sample forms with acceptable reasons. Notice how all of these are objective and directly tied to creditworthiness. Things like their income isn't enough, their debt to income is too high, or they have a limited credit history. These are tangible, non-discriminatory reasons.
And that brings us to our final and maybe most important section, compliance and enforcement. We've gone over all the rules, but what are the actual stakes? Why is it so incredibly important to follow ECOA to the letter?
Well, how about this for a reason? For a single individual who successfully sues a creditor for an ECOA violation, a court can award them not just their actual damages, but also punitive damages up to $10,000, and that's just for one person. For class action lawsuits, the penalties can soar into the hundreds of thousands or even more. So yeah, the financial risk is very, very real.
So let's wrap up with the key things you need to remember to stay compliant. First, record retention. It's not optional. You have to keep application records for 25 months after you've told the applicant your decision. Second, know who the referee is. For most lenders, the CFPB is the primary agency enforcing these rules. And finally, always remember the goal. This isn't just about a checklist to avoid getting fined. It's about upholding the fundamental principle of fair lending.
And that really leaves us with one final question to think about. It's one thing to check all the right boxes and follow the letter of the law. It's another thing entirely to build a process that embodies the spirit of fairness. So I'll leave you with this. Take a hard look at your process and ask yourself, is it just compliant, or is it truly fundamentally fair?